Joseph, I've heard about guarantees in contracts, but I'm not quite sure what they involve. Can you explain it?
Absolutely, Linda. A guarantee clause means someone, often a company director, officer, or shareholder, agrees to be personally liable if the company itself fails to meet its obligations. It's essentially a way to back up the company's promise with personal responsibility.
So, it's like a backup plan if the company can't pay its debts?
Exactly. Imagine a software company creating a custom application. If that company has limited assets, the client might ask the directors to personally guarantee performance. If the company defaults, the directors could be held liable for the financial loss. It adds real personal risk. They're putting their own assets on the line.
That seems really risky for the directors.
It is. But it also incentivizes them to ensure the company performs. If they know they're personally liable, they're more likely to stay involved and help prevent failure.
Are there legal implications they should be aware of?
Definitely. Ordinarily, a company and its directors are legally separate. But a signed guarantee overrides that. In some jurisdictions, the enforceability of personal guarantees can depend on factors like corporate structure, consumer protection laws, or procedural fairness, especially for small business guarantors. That's why it's critical to understand local legal frameworks and get professional advice.
Can you give another example of when a guarantee might be used?
Sure. Let's say a new restaurant needs equipment from a supplier. Since the business is new and unproven, the supplier might ask the owners to personally guarantee the payment. If the restaurant defaults, the supplier can recover the debt from the guarantors directly.
What happens if the directors refuse to give a guarantee?
Then the counterparty might walk away from the deal or ask for alternative security, like upfront payment or a deposit. In some cases, the contract may even include a remedy called specific performance, which allows a court to enforce what was agreed to.
What does that mean exactly?
Specific performance means the court can order someone to carry out their contractual promise. So if a person signs a guarantee and tries to back out later, the court can legally compel them to fulfill it.
Are guarantees always unlimited?
No, and that's an important point. Some guarantees are limited to a fixed amount, others are unlimited, covering the entire debt. You can also structure guarantees with conditions. They might only trigger after a certain default period, or expire after a set term. These details make a big difference to the risk profile.
How would that usually appear in the contract?
A typical clause might read, "The guarantor hereby unconditionally and irrevocably guarantees to the beneficiary the due and punctual performance of all obligations of the principal under this agreement. In the event of any default by the principal, the guarantor shall, upon written demand, immediately perform or procure the performance of such obligations and indemnify the beneficiary against all losses, damages, and costs arising from the default." This language makes the personal obligation clear and enforceable.
Are there any long-term consequences for the guarantor?
Yes, and they can be severe. If the company defaults and the guarantor can't pay, it could damage their credit, lead to asset seizure, or even personal bankruptcy. That's why no one should sign a guarantee without understanding the full financial risk, and whether they can realistically absorb it.
Do you see any changes in how guarantees work in newer business environments?
Absolutely. As more agreements move into digital platforms and startups operate across borders, guarantees are evolving too. Some digital contracts include automated enforcement triggers. And in cross-border deals, choosing the governing law and dispute venue becomes even more critical. There's also more scrutiny now on how guarantees are disclosed and consented to, especially with online-only signatories.
So, it's really about balancing protection for one party with real risk for the other?
Exactly. Guarantees give one party peace of mind but place significant legal and financial responsibility on the other. They're especially common in industries like finance, construction, and real estate, where trust and capital are deeply intertwined.
Thanks, Joseph. That really clarified things.
You're welcome, Linda. Guarantees are about accountability when stakes are high. And whether you're giving or requesting one, the key is to understand your exposure, structure the terms wisely, and never skip legal advice.